Продовжуємо роботу в Українському кризовому медіа-центрі. Вітання усім, хто слухає нас онлайн, хто знаходиться у залі. Наступна тема присвячена добору суддів місцевих судів як продовженню судової реформи. Зараз мова буде йти про результати першої частини відбіркового іспиту.
So the selection of local court judges as a continuation of judicial reform results of the first part of qualifying examination. Our guests are Serhii Koziakov, chairman of the High Qualification Commission of Judges of Ukraine, Stanislav, Shchotka, secretary of the Qualification Chamber of the High Qualification Commission of Judges of Ukraine, Dovydas, Vitkauskas, EU project coordinator, support of justice reforms in Ukraine, and Anastasia Dyomina, project manager, LC Ukraine. Welcome, dear colleagues. Good afternoon, dear colleagues. Welcome, everyone. We greet everyone who joined us today. It is a very important event that took place several days ago. And previously, many months ago, society, politicians, and active members of civil society, they said about necessity of clearance of judiciary, courts, from bad judges, and a lot has been done in this area, and now important step was in the most important part of reform, and this is the first step to renew judiciary and renew judges. And I would like to say, as practice have shown, and I believe that everyone saw this, that it is difficult to clear this area, and this is a special procedure, and renewal is even more important because the clearance is the view behind, and this procedure is a step ahead, and this is the result of the procedure we will see in some time. And today we are going to tell you about it. This is done step by step. New people will come, but it won't happen today or tomorrow. And those populists among the representatives of power who said a lot that all the judges should be dismissed in one day, now they come down and for some time, and they never said what time we need to have new judges. So now we are going to discuss this issue. And several days ago, not several days ago, but in April, on the 3rd of April, we announced, the High Qualification Commission of Judges announced the selection of candidates for 600 positions of judges of local courts, and the procedure allowed those who submitted all necessary documents and met requirements to the candidates. And I would like to say the difference between this procedure from the procedure that was several years ago, according to constitutional reform. Previously, young lawyers could be the judges, those who are not less than 25 years, having 3 years of professional experience. And now these are lawyers who are not less than 30 years of age and who have not less than 5 years of experience. And acting judges didn't take part in the selection. So what are the stages? Not one. This is not done quickly. First, this is a selection examination that was held several days ago, and also this is the verification in the sphere of fighting corruption and special training, and also passing special qualification exam. And my colleague, Mr. Shchotka, will tell you about it later. So more than 5,000 judges, 5,338 people applied. This is a record number. And before this, several years ago, we had 3 selections, and we didn't have such a big number of candidates, those who applied to undergo this procedure. So this is a record figure. So this is the national Guinness record, and 4,935 people were allowed to participate in the contest. There are formalized requirements. This is the number of years and the number of years of experience, and some people were not allowed to pass this test because of these formal requirements. Out of these 4,935, 4,525 had to attend the test, the examination, and we had 4,128 candidates. They passed not one test in one day, as it was done previously, but two tests. And first, they had the test in Ukrainian language, and then a law test. And one more slide I would like to show. The geography, where did these candidates come from? So the representatives of all the regions of Ukraine participated, from all the regions of Ukraine. And the next slide, out of these 4,000 candidates, the Commission decided that the next stage, 700 candidates will participate in the National School of Judges. So we'll have also psychological tests. So we have 700 winners of the selection examination. So this is the statistics. I would like to say that we've prepared the statistics, and we saw those candidates who won or who didn't won in the course of this test. That they so this is the statistics presented. 301 candidates. These are assistants of judges, and 399. These are other lawyers. So the law distributes this not according to the number, but according to two types of candidates. In the law, it is said that these can be lawyers. Any lawyer can participate, and also the candidates that work as assistants of judges for not less than 3 years. And we have 301 people who are the assistants, and 399 others. Female candidates and men. So we have this correlation. Previously it was more even, and now women are leading. I do not know whether this is the violation of gender equality. I do not know. Maybe analysts should advise us on this. And about the age. The majority of the candidates are 30 to 39 years of age. 40, 49, and then candidates 50, 58 years of age. So we had 3 candidates, and that are older than 60 years of age. We had 3 such candidates. And I would like to make a pause and give the floor to Stanislav Alexeyevich Shchotka. He is the secretary of the Qualification Chamber of the High Qualification Commission of Judges of Ukraine and former High Court judge. Good afternoon, everyone, and I hope that we have a big audience, and I would like to continue to tell you about peculiarities of this process, of this action that is called the selection of candidates for the position of judges. Why 700? So this was the state order for 700 judges, and it continues to exist. And on the day of selection test, the Commission took decision, and what was done during the day, but before the candidates completed this test, before we started to work on the results, we took decision that we will allow the special verification, not 600, but 700, those who will get the highest scores and will overcome the necessary established by law threshold, and this was 75% out of the highest score for separate tests, for language and for knowledge of law, and in the sum 75%, not less. Why 75? Why 700? We believe that this number of participants, this allows us to have 700 winners because they will have also psychological tests and maybe some participants, maybe minimum number of participants who will reveal low level, despite those who will have a mid or high level, and will continue to fight for proper positions. And also there will be special verification stage, and our experience shows that there can be some losses due to some deficiencies in the documents of the candidates, and then there will be special training in the National School of Judges, and previously not all the candidates allowed to special training really participated. So and after all this, there will be qualification examination. This will be the main event, and there they can get 75% of scores, and at each of the stage we can have non-battle casualties among the candidates, as we say. So on the whole, we believe that we will have less than 700, but more than 600. So I would like to say that we not only speak about figures, 600 and 700. We understand that before the qualification exam, and this is a reduced way. Also, there are candidates, lawyers, from the second selection, and by provisions 29, they are allowed to participate in qualification exams because they underwent all other stages previously. So Qualification Commission allowed this for 410 lawyers. So we believe that this will be 1,100 people. So these are people of reserve. And if they have proper attitude to all these procedures, they will be the basis and the rating out of which these will be the judges for the first instance courts. So we believe that this figure is close to 1,000. That's why those who like to connect the word reform with the word treason, you shouldn't do this, because we work on these issues, and we have such results and such hopes. And about all these stages, I would like to stress that special training is identified by law, and approximately 20 state institutions should provide answer to our requests about whether everything is good with the documents of the candidates. What about the diplomas, the military cards? Maybe there are some concerns relating to candidates or some conflicts with the law. So we do not know it yet. We do not have this information from the state bodies, but we presume that each of the candidates, that they are of highest degree. But we will have special verification, then there will be special training, and the law revealed such specific category that are the assistants of judges, and they should have experience of not less than 3 years. For this category, the law envisages, I won't say that this is a benefit, but the Commission can identify the peculiarities of training for this type of specialists. And this period of special training will be less than for other participants. It will be up to 3 months. And we believe that this will be 70 days, but this will be an intensive course. And the national school developed this course. This will be a 6-day a week during 10 days, and for other participants this will be about 12 months, and it will be 5-day week, 8 hours a day. And for one and second category, this will be the training at the National School of Judges, and they will be paid a stipend that is connected in percentage to the payment of work of assistants of judges, and this is not bad salary now. And what else? So after this training is done, there will be a qualification examination, and we believe that it won't be easy task for the candidates, and we believe this will be in-depth theoretical course that will be in the these will be questions for the candidates, and this course will be more difficult because these candidates they will be now compared at one platform, I would say a matrix. They will be compared with acting judges who want also to hold positions in other courts, in other territories, or in other locality, who want to work in other places. So in order to compare them, the platform should be unified and should correspond to a maximum degree. So so at the national school there will be really responsible training, and those who will pass this qualification test successfully, they will get rating score, and for 3 years this will identify their place in the rating and will provide chances to hold a position in the court where the candidate will apply after the contest of the commission. So when we carried out this procedure of selection, we tried to hear the feedback from the candidates. We know what discussions are held. We know who assesses us high and who criticizes us, and those who try to hide under some titles or pseudonyms. And I would like to say, especially to those candidates who want to know where they made some mistakes, and some candidates, they discuss these things on different sites, and they make applications, but we do not have any obstacles. You can make a request and you can get your results. Maybe a candidate forgot what answers he provided, and he can see the algorithms of answers that should be proposed. So we have such applications, and there are resolutions, and I provide that all the candidates had the access to the results. So if they want to do this, you may do this. So the questions and right answers to these questions, we won't do it for the candidates. Why? Because this database of questions and answers is unique, and this is in responsibility of the Commission and shouldn't be disseminated, especially answers. Otherwise, we would spend much time to create a new database. And if someone wants to file the case to the court, we will do it on the request of the court, but you should understand that this we are ready to explain to each participant, to tell the participant why he made a mistake, but only on this condition. So I would like to say that there are some issues, and the candidates, they express their emotions, and these issues, these questions, they were for all the candidates. The test was the same for everyone. There were options, but there were 40 questions in law and 100 in language proficiency, and some members of the Commission, they underwent a language test themselves, and we were pleasantly surprised that the results were more than 30 scores and higher, and maybe journalists also can do this test. And also there were anonymous requests to Commission. They draw our attention that some people tried to provide benefits to some candidates in some illegal ways. And I would like to say that we control these issues, and I would like to calm people down that those people, so these people who did something that is not right, they didn't pass this test. For example, one of the sons of the member of the Commission, he didn't become a winner in this contest. He was successful, but he didn't win. He didn't win. He didn't get more than 115 or 116. Out of 18 participants of the Secretariat who took part in this contest, the winners are only 6 people, and the rest, they failed. So you may assess whether the Commission really provided some benefits to those who work with us or who are our relatives. So those, the member of the Commission whom I've mentioned, he was suspended from all the procedures connected with the selection. He didn't have any relation to this procedure, and there was address to NEBO about the conflict of interests. There were special comments on this, and this member of the Commission didn't participate in this procedure, and also those representatives that wanted to participate in the selection also didn't take part in the procedure. And also there was an external control in relation to them, and they implemented other functions not connected with the selection process. So that is what happened. And we believe that this result is relative, and we are happy that this process was completed. There were a lot of people participating, and also informally some people, they built a mathematical model and looked through how results look like, and they say that this model is really good for the Commission, and I do not see any serious research on this, but we believe these people because often these people criticize us heavily for some things, and we hope that this first pancake in this procedure wasn't spoiled, and we believe that everything will be done based on principles we declare. This is open, transparent position and clear standards we introduce and make public in order that everyone understand what awaits for them. Thank you.
Thank you, Stanislav. We have one more question. It was just received at Facebook page. Nazar Pervak asked us and how we checked the texts for 2 days instead of 82 hours. The check-in procedure took less time, 1 full working day, and it was videotaped, so the record was available at our commission premises, and there were observers in the premises of the commission. We were not in haste. We were not in a hurry at the exhibition center, International Exhibition Center of Ukraine, and all observers who were present, and they saw the test for Ukrainian language skills when several days the video recorder was working, the video camera. It was even overloaded, and it failed to work to operate. Well, I did not try to accelerate the process of verification, so the check-in was going in usual manner, and it took 1 day. All personification of the result and several works, several test papers needed special attention. There were some curves or some ticks which the PC, the automatic program, did not recognize. These decisions were taken by the commission. These papers, they were discarded by the commission, so by the end of the day we took all the decisions within 1 day. Everything was according to the working procedure mode. And the question to you, why first the score, eligibility score was 40 plus 70, and then it was changed? This is the question of Lesya Ignatenko. Yes, this took time to take this decision based on our regulatory framework. I tried to already report that the 85% is the direct requirement in Article 73 of the law on judge institution. There was not 40 plus 75 score. 85% is 30 scores. So 75 true responses to the test questions should have been for eligibility to be selected by the Commission for further testing. A person should have been to overcome the threshold of 75%. Everyone who knows arithmetic, you can take from 140 or from by other method. In our regulatory documents, in the regulations on results of examinations, and there is a legal requirement in the law, then we should evaluate candidates against this requirement. We should interpret it so that there are no doubts that language test suppose 75% and the psychological test also will be 75%. A person can get 40 scores for law and 70 for the law test. This is the right of the Commission to interpret the norm. Article 6 saying that the procedure and methodology is responsibility of the Commission. So we have the powers and we used our powers. We have not changed the procedure and or the order in the course of this examination. Everyone knew that because we communicated the information beforehand. As concerns this threshold score, successful contestants, I have figures, it seems to me 1,273 persons who achieved the score, the threshold score. For our further selection procedure, we need less people. There were persons who achieved higher scores. The governmental order is connected to governmental funding, to curricula of the national school, with the opportunities of the national school to complete the training plan. So we need 700 future local judges who will be trained. So after the selection examination, we want to have no rumors that we sought to facilitate some candidates, and we want to prevent the myths. So before the test starts, we said to mass media sources that we will select 700 the best candidates. So why not 8 hours were spent? If a lawyer will read the requirement of the law, the Commission immediately after the selection examination start to evaluate and produce results, but the results they should be communicated next day. Article 1 of this law says that the selection examination consists of 3 actions: the law test, the language test, and third is testing of moral and psychological qualities of the candidates, and this third stage it will be later. It has not been completed yet, so legally we can announce results the next day after the third stage, after the interview on moral and psychological properties of individuals. But we understand that the community and candidates would not like this, so we took measures to conduct the evaluation to find out results with special automated software, and to get encrypted results with codes where we do not see surnames of the contestants. So we approved the results presented to us by the computerized system. Then we personified the results and saw the scores. The 700th candidate had 115 scores. There were 87 persons with this score, and we needed 1 out of them to be selected. Our methodology provided us the response. So far before, we decided that the candidate who will get the highest score in law test, he would get the right to be selected. We had 2 such candidates, and this algorithm also had the response: the priority will be given to the assistant. Both candidates were assistants to judges. We also had the algorithm, the candidate who has the more experience of the longer experience of work. So one of the candidates had more than 10 years of working experience as a judge assistant. The other candidate, a lady, she had 6 years of experience. So this is very simple answer to that situation. I'm giving the floor to our partner Dovydas Vitkauskas. We are very happy. Our EU project is happy with this results. Our task is to assist the Commission, Qualification Commission, with the test, and we continue providing our assistance. First stage was the selection to the Supreme Court. The judges have been selected. The judge should be a person, an individual, but capable to resolve conflicts in the society. To this end, the person should have special psychological qualities and social capabilities, communicative capabilities. So the process of selection and evaluation of judges has been institutionalized with the testing, and the Commission should get additional data, additional leverages on technological issues such as social and psychological and moral properties of the candidates, which can help Commission to limit their discretion while making final decisions about the candidates. So these tests, they provide higher confidence to the decisions. This way the Commission gets expert leverage, confidence in experts who give not only data but format and metrics of the assessment, how the psychological, moral and social characteristics should be assessed. So we have noble goals, and the process of Supreme Court judges selection demonstrated that the psychological test was beyond doubt in the society, whether it is needed or not. Even the members of civil society, they did not doubt the need of psychological tests. So I think this is very important component in the process of selection, and we are glad that we continue working with the Commission in this direction. So for expert answer, I'm giving the floor to Anastasia Dyomina. She represents our contractor. We have been working not for the first time, and Anastasia will give us explanation on the local judge selection procedure. Thank you, Dovydas. This is not the first time when we test moral and psychological qualities of judges. We took part in selection of judges to the Supreme Court of Ukraine, and now we are selecting local judges of the first instances. We use the same methodology, almost the same as we used for Supreme Court judges selection and evaluation. The only change what we took only basic psychological and moral qualities. If you know the methodology of selection to the Supreme Court, we used 4 methodologies. In this selection we use only 1 methodology, but we assess the needed qualities which judges need to perform their duties of local court judges, and to this methodologies as BFQ2 are used. We have already explained the details of this methodology. It means we have about 11 indicators, criteria of testing. Out of them we took such indicators as control of impulses, control of emotions, communicative skills, the capability to stand for own decision or opinion in the context of selection. If it is say that one methodology is used, there are many questions. There may be many questions, but testing of general capabilities is not used. It is usually gives rise to many questions. Only one psychological test will be used, and the narrow range of criteria for evaluation upon the findings of testing. Interviews with psychologists will be conducted in the format which is standard by the list of indicators. The optimum level of qualities and general opinion issued by psychologists, which will show us risks and advantages of the candidate. As if we talk about the general psychologist's opinion, our colleagues have already said that psychologist will give the level of compliance to the profile, which will be either high or medium or low. We assessed the candidates to the Supreme Court. Not all of candidates were eligible by experience. Those candidates which demonstrated low level of compatibility with the ideal profile. So if this match with ideal profile will be high or medium, this would provide the Commission the opportunity to take balanced decision. So talking about an ideal profile, I would like to say that the methodology is not discriminative. If the level of match with ideal profile is low, it does not mean that the candidate has low moral qualities. We just can say that this person demonstrates low compliance with the best local judge profile, so does not match the requirements to this post. There is one question left. From Lesya Ignatenko. How in future the fates of individuals will be decided when technologically the surnames of candidates were not identified? There were only 14 papers like this. About 2 papers, I have already told you that there were some markings which have not been recognized by the software. In this case, the Commission may either check these papers if it is possible, but the Commission decided that it is not possible to check those papers manually. So only 2 candidates out of 4,000 use some illegible markings. The other papers, one candidate for some reason missed the code number in the last box. That is why this paper was discarded. 2 candidates, 1 candidate, the 4th person, he in one place made a mistake for some reason in the last box. So the code was not his, but of the other candidate. That is why as a PC which checked already the paper with this code, the Commission believes this mistake was significant and the paper was discarded the first day. when the language test work was tested, the PC was working in non-stop mode, and it was hot in the room. So 10 papers were not checked by the PC due to the problems with this PC. So there were no mistakes in codes or illegible marks in those papers, so there was the reason in scanner technological problems. The Commission checked those papers manually and gave them scores. These 10 papers that were checked manually, Ukrainian language test papers, they were accepted by the Commission, and the candidates, according to the findings of the language test, they continued their way in the process. The 4 papers were discarded, so the candidates were rejected. Are there any more questions? We're ready to answer your questions now.
Tatiana Yushchenko, Ukrainian Institute of the Future. I have several questions. First to Serhii Yurievich. Serhii Yurievich, tell us, please, what European partners helped you to implement the selection of candidates for the position of judges and to carry out qualification assessment for the new Supreme Court? And also question to Stanislav. We heard the argument that final test will be attended by 1,000 participants, but we see that assistants will have special training for 3 months and other candidates will be trained for 12 months. So this should be one final test for everyone in July 2018, or that should be several tests for those assistants who will study with and then for all other participants. And the second question, if we look at the law, there is special verification. There should be verification of declarations, and Part 2 of Article 75 limits the scope, the time frame. 30 days are allowed for this. So in what way do you plan to coordinate these actions? That these declarations were filed in spring 2017. Should people file these declarations anew, those who so I would like to once again thank Dovydas Vitkauskas, the coordinator of EU project, and they really help us in our activity, and we do not have problems in our cooperation, and this help in psychological testing that will be held. This is a huge work, and this testing will be done during some time, and computer software also should work properly. This is serious work. I would like to say that we have one part of work. This is the monitoring of all our procedures. For this monitoring, we invite our colleagues international donors, the project I've mentioned, and the USAID project, and the projects of the Canadian government, European Council, and maybe I've mentioned everyone. So the monitoring, when our colleagues come and they provide the criticism in case of necessity, if there are grounds for this, and we try to resolve the problems according to the advice. So this is what I've wanted to mention. So answering your second and third questions. So the answer is like this. So present situation and the problem with the problems, the challenges in the judiciary we face, it would be logical to give opportunity to the assistants of judges to undergo special training, and according to our estimates, we have 301 such candidates. After they are properly trained, and we have 410 candidates that were allowed to participate, those who were in reserve and who participated in the second selection of the candidates for the positions of judges. And so we can calculate these 711 people. And in my opinion, and I forecast that if we announce a contest at this stage, what would we win in the situation? We will win time. We shouldn't wait for the deadline of the training of other candidates. For example, imagine that we will have 350 plus, and there can be a contest announced for the assistants who passed qualified examinations and the candidates of the second selection who passed this test, and those acting judges who are now can also be transferred, realize their intentions for this. So we forget that there is a list of candidates. We usually do not say about them, but we have tons of such candidates who got recommendations from the Commission some time ago, but they were not nominated for the positions. And these candidates, they have the right to undergo this examination at the stage. And I do not know whether my forecast is accurate, and not us, but Commission should collegially decide whether the contest can be announced. For example, for the summer 2018, to fill these vacant positions. And I believe that if there is 1,000 candidates, that will be a great contest with big competition. And someone is in panic and they say that Commission wants to help some categories, for example, assistants, to help them get good positions. But we do not speak about these good places. We speak about the positions that should be filled in the courts. In some courts, specialists are lacking. So we should pay more attention to this, and we have methodology how to identify where the situation is difficult or extra difficult or hyper difficult, and we use these methods in order to identify how to correct this crisis situation. And So this is our reality, and we do not say that this is tragic or dramatic. We work with this situation step by step. So I personally will propose this algorithm to my colleagues for discussion. And how it will be perceived, we will see. The Commission will identify. So we have such a thing. So you can look at infographics. Special training will start on the 19th of April, and we believe that we maybe will have it. Maybe this training will start 1st of February, and we will have more time to resolve the situation, because we undergo several procedures at the same time. Concerning your second question about, please remind it to me, about whether there is a need to submit a declaration. The candidate submitted declarations. This is required by law, and they submitted electronic declarations, and we, as a Commission, send a request to a proper body. This is the National Anti-Corruption Commission, and we get proper information. And they provide the answer about the candidate in the framework of laws, anti-corruption laws. The law does not demand additional documents from the candidates, and it does not oblige the Commission to request for documents that are not envisaged by Article 72.
I would like to give the answer to the questions from Facebook. Lesya Ignatenko continues to ask us questions. It is interesting why we have not been provided comfort. We were standing in cold conditions for a long time. Yes, those who came for 9 a.m. they were standing in cold condition longer. Candidates were invited 15 minutes before testing procedures, but many people they were standing longer. They came earlier. When I saw that the queue is accumulating, I approached the candidates, and the candidate told me that 50 minutes he was in a queue, and I compared with the answers of other candidates. So for 1,000 candidates, unfortunately, they arrived by public transport, and they could not calculate the precise time of arrival. That is why it was a queue, and why also the nobody sold hot tea and sandwiches, and also why water closets were not sufficient. 150 persons of staff were testing, and also there were candidates who wanted to visit water closets for 2 times, and we should have been observing whether these individuals use some gadgets to answer the questions. Yes, when even we provide mineral water, then we are asked where we took funding from. Why it was so cold? Of course, we would try to improve the health state of our candidates. If you were sitting close to the exit, maybe the candidates who were exiting, they did not close the doors. Pluralism is the word. Tatiana Vorobyova. I suppose she is not a bot. The record high large-scale event was organized in professional way. Given this large scale, all details were rather well organized, and Mariana Stapenka also answers that the candidate himself or herself, there is a human factor. Those individuals who are appointed for 7 o'clock a.m., they will come in time. This was happened in fact. There is yet another post on this forum. Tatiana Shevchenko, thank you for a very good organization in the hall. It was warm inside and everything was organized in the best way, in the well-balanced way. How can we compare? Maybe this is physiology of some bodies. Maybe the truth is in somewhere beside the extremities, in the middle. Maybe there were some sectors where it was warm enough in the premises. Let's come to some conclusion. I saw where tea and sandwiches were sold. I visited the water closet and I saw its capacity. There were very many free spaces, at least in the men's WC. I would like to mention several details. I saw 3 pregnant participants. One of them was on the 9th month of pregnancy, and one was nursing mother, breathing mother. So every 2 hours she went out to feed her baby. 10 times we helped the participants who felt bad due to nervous disorder or other disorder. Whether a person should quit his job for the period of training for a judge. Yes, I think that you should quit your job because you will be paid a scholarship during training. but the vacancy will remain fixed to the person who is undergoing training. Those participants whose tests were successful but who did not get enough scores. Well, every time with every new selection, the candidates they become the criteria to candidates become higher and higher, when the level of testing was higher as well. I would like to model the situation in future which may happen when the individual's declaration is checked, cheating is found or mistakes are found. Then this would be beyond the period set by the law, and if the Commission stops the participation of this person, then the person may use Article 19, saying that the governmental body should follow the procedure as set forth in the law. So I think there may be a threat that the decision of Qualification Commission may be decided invalid. Talking about Article 19, according to Part 2, you remember it, I think we just act this way, so this is the powers of the other governmental body. We considered Article 75 of the law on the status of judges, and we will have a joint meeting with the National Anti-Corruption Bureau, and we will address this issue jointly. The contest for those who would have passed the examination in the High Qualification School of Judges, there the National Anti-Corruption Bureau of Ukraine also may send us some documents which we do not know now. There will be many filters for selection, for screening of candidates. That is why we are now choosing 700 candidates but not 600 candidates. Pavlo Koropchuk, Chesno movement, filter the court. Maybe this third stage should be conducted along with the first two tests. The psychology will have more influence on the professional's decision. So by psychological testing, maybe 40 or 50 persons will be screened. This is 100 times less than 3,300 people that have been screened and rejected already. Please give us your question in written, because we should compare what you said with the law and regulatory framework of the Commission, because the Commission also issues regulatory acts. After that, the work starts, what should start at 9 o'clock, what should start in the other time of the day. When you say that the third stage should take place the same day, I have a specifying question. Would you like it to be conducted the same day? Your colleagues just like us to give yes or no answers. Do you know the technological chain of psychological testing? Do you know that this includes not only PC test but also an interview with psychologists? Just answer yes or no. I know. Yes, that is why I am asking you. Let's just imagine that 4,128 people are sent to psychologists. So then how many psychologists then we need for interviews? Here you see contractor. Just let's multiply 4,128 persons per 30 minutes. This would be 2,000, more than 2,000 hours of psychological interviews. It is more logical to check the professional level of those persons. Why should we synthesize all the tests? It is physically impossible to conduct all three stages on the same day. 3,000 persons have been selected by language criterion. Maybe they could have demonstrated very good psychological qualities. To be precise, the number of rejected individuals is 3,418 persons. They have been rejected not by language criteria but by the by two test results. Maybe their psychological qualities are good, but if even a congenius personality would not pass then the language test or a law test, then this would not provide us anything. We just could have known that this person is congenius, but he or she should study law and language. The test was not too complicated. I can demonstrate it to you. Tell your colleagues from Chesna movement that we are ready to meet with your members of your movement, and to explain our procedure and the technological chain, how it happens. 150 staff of our secretariat, many of them have not slept for 48 hours. They are working simultaneously in the premises which are as large as 3 national stadiums. We will explain to your activists everything, how such large-scale events are carried out. Within 1 year, we organized 2 events, the selection procedure to the Supreme Court and the selection event for the testing for local court judges. It is like the Eurovision by scale. Any more questions? Thank you to everyone. please ask your questions of records, because we are short of time. You can see the video record on YouTube of the